If you get as far with your disability application as a hearing with an administrative law judge, it is likely that a vocational expert will testify at your hearing. A vocational expert, or a VE, is an independent contractor that is hired by the Social Security Administration to provide expert testimony about the types of jobs that are available in the national economy and the requirements of those jobs. Their primary role is to assist the judge in deciding whether or not there are still jobs in the national economy that you could do despite your medical limitations. During the hearing, the judge will often ask the vocational expert hypothetical questions, starting with assume a hypothetical individual of the same age, education, and work experience with the following limitations. The VE will then use their knowledge of the job market and data from sources like the Department of Labor to answer if there are jobs that hypothetical individual could perform. For example, they might testify how often you can sit, stand, or use your hands to perform specific occupations. They also might testify about whether or not breaks beyond the standard are tolerated in most workplaces. This testimony can make or break a Social Security disability case because Social Security uses it to determine whether or not there's other work in the national economy that you could do. If you have a lawyer, they will most likely cross-examine the vocational expert. This is critical because a lot of VE testimony depends on how the attorney frames the question. Your attorney will also challenge any inconsistencies or point out any limitations that the VE might have overlooked, which could strengthen your case. So the VE is not there to take your side, but they are also not there to argue against you. Their job is to provide information, and your lawyer's job is to ensure that it is accurate and fair.